Probate is the process of handling the legal affairs of a deceased person. The first step in the probate process is for the person in charge of the estate, who is known as the executor if the deceased person had a will, or an administrator if the deceased person died without a will, to file a petition. As part of the process, the executor must file the original will with the Riverside Probate Court or San Bernardino Probate Court and publish a notice of death in an authorized newspaper. In many circumstances, the executor or administrator must also post a bond. If the probate judge approves the petition, the executor or administrator will receive letters, which is the official document authorizing the person to act. The executor or administrator can then give notice to all known creditors so that they may file a claim. When creditor claims are received, they can either be accepted in full or in part, or they can be rejected. The executor or administrator must contact various state agencies, such as the Franchise Tax Board and the Department of Health Services, to ascertain whether they have any claims against the estate. The attorney for the executor or administrator can often negotiate a reduced payoff of these claims, saving the beneficiaries of the estate thousands of dollars. The executor or administrator must also file all income tax returns for the decedent as well as for the estate. During the probate process, the executor or administrator must inventory all assets of the estate. If the decedent owned real property or business assets in more than one state, it may be necessary to open probates in all of these jurisdictions. The executor or administrator opens up an estate bank account and keeps estate assets separate from his or her assets. The income and assets of the estate are then used to satisfy the debts of the decedent. When all the claims have been satisfied, the estate is ready to close. The executor or administrator would then prepare an accounting, unless the accounting is waived by all the beneficiaries, and a final report detailing to the probate court how the remaining estate assets are to be distributed to the beneficiaries. If there is no will of the decedent, the assets will be distributed according to state law. Upon approval of the accounting, if required, and of the final report, the judge will issue an order for the executor or administrator to distribute the assets to the designated beneficiaries. After the assets have been distributed, the executor or administrator files receipts with the court and the probate is closed. The process takes a minimum of 7 to 8 months from start to completion, with the average probate in Riverside and San Bernardino counties lasting about a year. The maximum fees to be paid to the executor administrator and to the attorney for the executor administrator are set by California law. The executor administrator and his or her attorney may also charge extraordinary fees, which must be approved by the probate judge, for tasks such as selling real property or a business, handling complicated tax matters, or managing a business on behalf of the heirs during the probate process. In some circumstances, a probate administration can be avoided. This may be where the estate is below $150,000, where the surviving spouse has claims to the assets, or where the decedent intended his or her assets to be owned by a revocable living trust. In some of these cases, the probate court may not need to be involved, and in others, a petition may need to be filed, but the cost and time delays of a probate can be avoided. If you need assistance with a probate in Riverside or San Bernardino counties, call 951-787-7711 to schedule a free 1-hour consultation with one of our estate planning attorneys or our probate paralegals. You can also get additional information about probate by visiting our website at www.protect-your-wealth.com.